Welcome to the Probate Nation. As loved ones age, they often need assistance making their care and financial decisions. And frequently a family member has to petition the local court to obtain that legal authority as either a guardian or conservator, or for that matter, both. The process to be appointed to those positions is like a carefully choreographed play with many actors. You know, there is the petitioner, the respondent, attorneys, the circuit court judge, and possibly a jury, and each has a different role to play. In an earlier show on this topic, we sorted through some of the initial questions about the GAL, including who can be a GAL, how they are appointed, the role of the GAL, and the type of investigation the GAL does. In our show this evening, we continue to sort through further questions about the GAL as the petition progresses through the litigation process. We are pleased to have returning our guest from Part 1 show to serve as our guide as this courtroom play continues. So let me introduce our first guest, is the founder and owner of Bromley Law in Fairfax City. His practice focuses on probate, trust, estate administration and litigation, and guardianship law. He has previously served as co-chair to the Fairfax Wills and Trust Estate section of the Fairfax Bar Association, and has also served as a law clerk for the Fairfax County Commissioner of Accounts. He serves as a court-appointed GAL for incapacitated adults in Northern Virginia court proceedings. Our second guest is of counsel with the Meyerson Law Group in Reston, Virginia. His law practice covers both criminal and civil matters, including business and contract laws, matters, civil litigation, and criminal and traffic defense. He has served as a GAL for incapacitated adults in guardianship and conservatorship proceedings in Fairfax County since 2010. Please welcome back attorneys David Hirsch and Jonathan Bromley. Guys, welcome back. David, I'm going to go right to you as we're going to jump into this. Does the respondent have any statutory rights? We've talked all about the GAL's role and how they have to do certain things, but what rights does the respondent have?
They have a broad array of rights. They have the right to have a counsel, an attorney represent them. That can be either appointed by the court, or if they wish to hire their own attorney, they have the rights that any other litigant would have in our court system. That includes issuing witness subpoenas, document subpoenas, the right to question witnesses, the right to call witnesses on their behalf, the right to be present at the hearing, the right to a jury trial if they choose. So they have all the rights that are vested with any person who is in our civil litigation system.
Well, those are very, very broad rights. Of all those rights, any one of those rights in particular really jump out at you as being most important in this entire process?
No, absolutely. The right to counsel is paramount. If there's any sense by the person that they object to the proceeding, or if there's any sense by you that the question of capacity is not cut and dry, then I view it, you must have an attorney for the respondents.
Jonathan Bromley, I'm going to come to you now because David just touched on probably I think the key thing we're going to talk about next is people need counsel. And so tell me a little bit about the role of the attorney who is either appointed by the court or retained. What's their role in representing the respondent in this case?
Well, again, as kind of touched on, a judge is going to ensure the person is represented if they want a lawyer. So a lawyer's job is a little different than the guardian ad litem's job. So the guardian ad litem is going to make recommendations of what's in this person's best interest. So he or she might say, well, this person needs a guardian for these reasons. The lawyer, on the other hand, serves as a role as a lawyer in any other case. Their job is to advocate what this person wants. They don't want a guardianship, they're going to put on the best case possible as to why they don't need a guardianship. They don't want their oldest son to be their guardian, but they want their daughter to be their guardian. They're going to put on a case to show that the daughter would be a better fit for this individual. But again, very different than the guardian ad litem's role, but very important in making sure that that person has an opportunity to be heard.
So if a respondent, the GAL visits the respondent and they say in response to the GAL's question, do you want to have an attorney? Okay, and the respondent says yes. What are the options for the respondent at that point as far as getting counsel to represent them?
First thing the guardian ad litem is going to do is he's going to basically put a pause on the proceedings until this person has a lawyer. It's extremely important that they are represented in that situation. The person could hire their own lawyer. I rarely see that happen, and I think one of the issues that comes up is lawyers would be very concerned about being hired directly by somebody who's being alleged to be incompetent. The problem being, do they have the ability to legally hire me and make a contract with me? So in most cases, a guardian ad litem would actually bring this to the court's attention, and a judge would appoint someone to represent the individual who's familiar with guardianship law and the intricacies of these proceedings.
Okay, and we'll come back to that in a second, but I think that one of the things people always ask is part of this process may determine that the respondent, the proposed incapacitated person, might be indigent, not have enough resources. Would the court appoint somebody to represent that person, notwithstanding the fact that they have no money?
Absolutely, Richard. I mean, and in fact, the state, the same fund that pays the guardian ad litems when the person's indigent, would actually pay for a lawyer to represent that person as well. A lawyer is so crucial to the process that the case cannot proceed if they want one. And in fact, when the guardian ad litem talks to or advises the court, if a lawyer is not requested, it has to advise the court as to why a lawyer is not necessary in this case. So the short answer to your question, again, I kind of went beyond it, Richard, but the short answer to your question is yes, they will get paid, but they will be paid by the state at a reduced rate from what they would make in their private practice.
Well, Jonathan, I'm going to continue with you, though. When the guardian ad litem finishes all of their work, okay, what do they do with all this information?
Well, they're going to compile it into a report that lays things out in a logical fashion that can be read not only by the court, but by the parties. So, it gives everybody sort of a preview of what's being found, what is the evidence showing, what's in this person's interest. But they would take that report and they would file it ahead of any hearing, and that would give the opportunity for everybody to get a sense for what the facts are, and also for the court to be aware of the nature of the case and what it might be required to do.
David Hirsch, I'm going to come to you. So we have this report that's filed. Tell me how it's handled or how it's treated or how important it is in an uncontested case versus a contested case.
It's equally important in both because it's the judge's initial and primary means of getting information about the facts of the case and the recommendations.
Yeah, that really is true. Well, let's talk, I'm going to come back to you, Jonathan. Let's talk about uncontested hearings. Tell me a little bit about what happens in an uncontested hearing.
Yeah, so in an uncontested hearing, it's sort of a short form guardianship. The person's met with the guardian ad litem. Guardian ad litem advised them of their rights. Person might have no ability to resist. In other words, they might be in a coma or some state where it doesn't make sense to get them an attorney. It might be a situation where you have an autistic child who has no concerns with continuing to live with his parents and continuing to let them act as his decision makers. And in those cases, we would have set it on an uncontested docket. The court or the judge in this instance would read the report, get some background. Everybody would come to court. Usually the respondent is there as well if they're able, and the court will take the advice of the guardian ad litem and the agreement of all the parties and appoint a guardian and/or a conservator.
So, David Hirsch, so Jonathan talked a little bit about how the GAL report's used. Tell me a little bit about the role of the GAL at the hearing in an uncontested matter.
At the uncontested matter, the GAL really has a minimal role at that point. The judge will acknowledge that they've read the GAL report. On occasion, the judge may have a couple of questions on that report, so the role of the GAL is to answer the judge's questions. And sometimes the judge may ask the GAL to confirm that, yes, this is the right thing to do and this is the appropriate person to be appointed. So it's a fairly circumspect role, and it's really dictated by the judge's direction.
And David Hirsch, how long does a typical uncontested hearing take? Now, certainly in Fairfax, I mean, it's one we have a lot of experience with, but how long does it normally take for uncontested hearing?
Normally takes for an uncontested hearing about 5 minutes, and that's really to process the order the judge must sign and the paperwork.
Okay. And then are those records then sealed?
The GAL report is always sealed.
Okay.
The other part of the case file is not sealed to my knowledge.
Okay. Let's talk a little bit about contested hearings. Now, I know, David, you had a lot. I'm going to stay with you. Tell me what happens in the contested hearing. Okay. How do things flow, and how does the GAL kind of fit into that?
Well, Richard, what doesn't happen in the contested hearings? The GAL's role in those hearings is to continue to advocate for the best interests of the respondent. I find that when they actually go to a trial, a lot of attorneys that practice in estate planning and areas such as this aren't in court a lot. And so sometimes by default, it falls to me to take the lead in the courtroom in terms of calling for witnesses and questioning witnesses and introducing evidence. So my role is similar to that of the other attorneys, except I'm not an attorney for the party. But I will call witnesses, issue witness subpoenas, I will file a list of exhibits, and participate fully in the argument of that case and in questioning witnesses. Another thing I try to do when we have a contested case is to try to steer the parties towards a mediation, usually using a retired judge, and try to find the parties to an agreed, conciliated resolution that everybody feels they had a part in making, and it also, of course, greatly reduces the cost of a full-blown litigation.
Well, I think that's one of the big challenges with contested litigation. Jonathan Bromley, I mean, how long do you see these contested cases typically taking?
Well, the code puts this as a priority on the court's docket, and so most cases are supposed to be heard within 180 days. And practically speaking, most cases take a while. You know, there has to be discovery, there has to be opportunities for people to get information and to gather witnesses. Typically, I see these cases being heard within 3 or 4 months of their filing. But if there's resolution discussions, we might put it off to see if we can find a solution. But it could take a while. Everybody has to have an opportunity to be heard and have an opportunity to get the information they need to present their case.
That's true. So let's talk a little bit about, let's get into a topic that is a little bit uncomfortable for some people, and that is, let's begin with, who pays the GAL? If we have a contested or if the respondent has their financial resources and it's not indigent, who pays for the GAL services?
Well, if he's not indigent, usually that person is going to pay. The respondent's going to pay, since the proceeding was initiated for that person's best interest. But that presumes that the petition was filed in good faith. So if a judge feels like that there was an ulterior motive or that there was no basis to the case that was filed, he can actually decide to make the petitioner pay for the guardian ad litem's fees in those instances. But in most of these cases where there are assets, it is going to be the respondent that's going to pay for the services.
And if the respondent is declared or found to be indigent, which they don't have any assets, and typically we see that especially with people who are turning 18, the young kids that are turning 18. If they're determined to be indigent, who pays for the GAL at that point then?
Yeah, so the judge will review the invoice and make sure that it's reasonable, and then if approved by the court, it'll be submitted to the Virginia Bar to be paid out of the indigent fund, the same fund actually that they would use to pay for appointed lawyers to represent people in criminal cases.
Right.
So
and it's important for, I think, the audience to understand that the hourly rate that they will pay for an indigent is set at a very, very low rate because it's considered that the GAL is doing this as a matter of public service. So it's not, they're not getting paid much, as we well know. But John, I'll continue with you though. Who pays the fees incurred by the petitioner? Okay, so that's another subject. In other words, let's again, if the respondent has the financial resources, who's going to pay the petitioner's fees? They've hired a lawyer and gone through either an uncontested or a contested hearing. How are those fees handled?
It's a similar analysis to the Guardian Litem's fees, Richard. So in most cases, the petitions are filed in good faith. And if the court feels that is the case and the respondent has the assets, it is the respondent who will pay the petitioner's legal fees or reimburse the petitioner, really, for their legal fees. Again, under the theory that this was done on their behalf for their benefit, essentially. Now, if the resources are not there, then unfortunately the petitioner is going to be having to bear their own legal fees. There's no fund out there for providing legal fees to petitioners and their counsel when there's no assets for the respondent to pay.
Sure, and that is an issue sometimes. Now, I think the court has taken a very serious look at the fees that would be reimbursed. Okay, to the time, and in other words, they're a little concerned about everybody doing a great job and representing people very, very aggressively and appropriately, and then presenting a bill that's just huge compared to what the resources are of the respondent. Have you seen any judges adjust the fees because of that?
I have. There was a time there was a lot of abuse. This is not recent. This is historical, where Guardian Litems would unfortunately make this a major part of their practice, and they would go out there and spend more time and bill higher hours than they ought to. The judges now are way more cognizant of that. They will take a close review of the legal fees that are being charged, and they will make sure that they're reasonable in light of the case and the work that was involved and the assets that are available. Most Guardian ad litems that do this, even those who are being paid by a respondent, will do it at a reduced hourly rate than from their private practice rate, really under the theory that this person didn't have a choice. They didn't get to choose to hire us. So most of us will basically cut our hours in some sense, and I know the court's very appreciative of that.
Now, David Hirsch, I know I'm coming back to you because I know that we've had this discussion and that you have dealt with this yourself, because I know that you actually have a lower hourly rate whenever you serve as GAL as well. Is that true?
That is correct. I cut my rate by more than 40% in these cases.
Sure, and I know we do the same. So, well, let's go on and talk a little bit about, something we've covered a lot of territory. We've been through part one, now we're part two. We're getting to the closing act of this particular play, and let's kind of bring it together with what are the common problems that you see based on our discussion tonight that the GAL faces. David Hirsch, I'll stay with you on this question to start.
Other than those we may have mentioned in a previous show.
Yes, sir.
Getting information sometimes is difficult. I would say that dealing with the banks is particularly difficult. One frequent problem I have is the bank doesn't understand the difference between a guardian and a guardian ad litem. So I present my raised seal, certified copy of the order, and ask for records. The next thing you know, the bank is putting me as an authorized person on the account.
Oh my goodness.
And that has happened to me repeatedly. And I go in and I try to explain, and sometimes have to track down the legal office for the banks and say, you can't do this, you can't put me on as a responsible person for this account. That's one I frequently run into. Another one is it's not uncommon to have family members or identified witnesses just refuse to want to participate or provide information. And sometimes it's even hard to get the doctors to cooperate.
Jonathan, how about yourself? What have you, some final thoughts or some words of advice based on our discussion tonight?
Yeah, a lot of times, unfortunately, what I run into is the petitioner is represented by an attorney that might not be as familiar with this area of the law. And the Virginia Code has a lot of very particular requirements about what needs to be in the petition, what type of information needs to be in there, what needs to be alleged. And for example, there needs to be a medical certification filed under seal and a financial addendum filed under seal as well, describing what the assets are. And when I see that, unfortunately, the problem is I have to go back to the petitioner or their lawyer and let them know that we can't proceed. You know, the information that I need in the petition to serve and to properly allow this to proceed and advise the court that it should proceed just isn't there. So, you know, luckily over time, lawyers are getting more familiar, and especially with the General Assembly changing the requirements from time to time, really in light of what happened out west with Britney Spears. And, you know, a lot of the General Assemblies really tightened up what it is that needs to be in these petitions and what it is that the guardian ad litems need to do.
Yeah, it really is true. But let's go ahead. We're getting to the close of our time. So we now finished up, you know, the final part of part 2. Jonathan, I'm going to stay with you and ask you to just kind of give us some closing comments, pitfalls to avoid that you would suggest that people keep in mind when they're dealing with the guardian ad litem.
Well, if I was attorney for the petitioner, first thing I would tell him is the guardian ad litem is not your friend. I mean, he's obviously there to perform an important role, but, you know, what you tell the guardian ad litem is not necessarily, it's not confidential. You know, the same with the respondent. You know, when I meet with a respondent, I let him know that, you know, I'm not your lawyer. What you're telling me is not private. If I feel that something you're telling me, either from the petitioner side or from the respondent side, needs to be part of my report and that the judge needs to be aware of it, I'm going to include it. So, you know, I think that people have to understand that they really ought to talk to the guardian ad litem so that they can share their views, but they have to be aware of the fact that he doesn't represent you.
Okay. David Hirsch, how about yourself? Some final comments? Do you want to button up this particular discussion in a way that give people some guidance about how to deal with the GAL and the role of the GAL?
As with many other things, proactive law is much better than reactive law. I can't emphasize enough the importance of proper planning while you're still healthy, while you're still in full possession of your faculties, and avoid putting your family through the strain and expense of one of these type of proceedings. The more prepared you are in terms of preparing for the future, advanced medical directives, wills, powers of attorney, that's important. And I also would recommend that anybody who's preparing these documents convene a meeting of family members, especially if you have a situation where there's a second marriage and adult children from each of the marriages, which can be a real tricky area, that you gather all of them and you say, I want you all to know these are my wishes. These are the documents I have prepared. These are my plans. So that kind of, the more you plan in advance, the more you communicate in advance, you don't run the risk of being put through what I consider and the indignity of a court having to declare you incompetent and strip you of your rights.
Well, that's sound advice, David, and I want to thank both you, David Hirsch, and Jonathan Brownlee, for taking the time to speak with us and educate our viewers about the role of the GAL, who's an integral part of the whole process as that particular play unfolds over there in the courthouse. So again, guys, thank you for this great public service, and I do very much appreciate you taking the time.
Thank you for having me.
Thank you, Richard.
There's much that needs to be done to successfully prosecute a petition for the appointment of a conservator and a guardian. A misunderstood but key contributor to that process is the court-appointed guardian ad litem. In the show tonight, we completed our conversation about the role of the GAL by addressing the importance of her report to the court in both contested and uncontested hearings, who pays the fees of the GAL and others involved in this courtroom drama, and some of the common problems the GAL encounters along the way. This concludes our show this evening, and we hope you found both Part 1 and Part 2 informative. Just a reminder that replays of these shows can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly tips on guardianship, conservatorship, and probate, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.